Well, hello there, folks. Bill O'Leary here, coming to you in this video. And the question I'm going to talk about is whether assets that are held by a trust get a basis step up at death. So in this video, you're going to learn three things. One, what is the basis in an asset? What is basis? Two, how can basis change when someone dies? And three, whether that same change in the basis can occur if the asset is inherited through a trust rather than directly. So again, by way of introduction, my name is Bill O'Leary. I'm an attorney that I focus exclusively on estate planning, elder law, and probate. My firm is Legacy Planning Law Group in Jacksonville, Florida. So look, in another video, in an earlier one, almost as an introductory type video, I talked about what a step up in basis is. Now, here in this video, I'm drilling down and talking about, okay, do you get that same step up in basis if the asset is inherited not directly, but through a trust? And what impact does that have on capital gains taxes? So to recap, capital gains tax is a tax that is assessed by the government when a capital asset is sold. Things like stocks and mutual funds and real estate, that sort of thing. A tax is owed if the asset is sold for more than the basis in the asset, okay? Now, what is basis? It's just a tax concept that's used quite effectively to determine what taxes are owed when an asset is sold. It's a way to measure the precise amount that's due. The basis amount is initially set at the price that was paid for the asset. And then this basis goes up or down. It may go up if you've made certain renovations to the assets, to the property, improvements, whatnot. It may go down if you took certain tax deductions, things like depreciation on real estate or a building, equipment, that sort of thing. So it's very much of a moving target. Now, at death, the basis is adjusted to what the asset is worth on the date of death. And a step up in basis occurs if an inherited asset is worth more on the date of death than the original purchase price. So, simple example, let's say your uncle, I like to talk about the uncle, leaves you a piece of property that he bought for $100,000. That is his starting basis. By the time your uncle dies, it has gone up in value to $250,000. And when you inherit it, the basis that you now have, your starting basis, is stepped up from $100,000, that was his basis, to now $250,000, what it's worth when he died. Now, let's say you decide to sell the property, just in a hypothetical situation, one day after your uncle dies for that same $250,000 that it was worth the day before when he died. It didn't go up in value over the course of a day. So in that situation, you sell it one day later, no taxes due because it's not gone up in value from what it was worth on the date of his death. Let's say instead you decide to sell the property 6 months later after your uncle dies, and at that point it's gone up in value somewhat over 6 months. It's gone up by $25,000. It's now worth $275 instead of $250. Okay, and you sell it. You're going to have to pay capital gains tax, but only on the $25,000 of increased value during that 6-month period. Now, does anything change if your uncle held the asset in a trust and you inherited that asset through the trust? Do you still get that step up in basis? Well, the answer is yes, if your uncle held the asset in what's called a revocable living trust. And the reason why you still get a basis step up here with a revocable trust is because if a trust is revocable, your uncle could have revoked it or canceled it. And since he could have revoked it at any time, the asset is still considered to be owned by him for tax purposes. On the other hand, if the asset was held by your uncle in an irrevocable trust that he set up while he was alive, you typically would not get a step up in basis. And by the way, an irrevocable trust is just what the name implies. Once you establish it, you can't revoke it or cancel it. And since you can't revoke it, the tax laws say that your uncle in that situation truly parted ways with that asset when he transferred it to the irrevocable trust, and it was no longer considered owned by him in the eyes of the tax law. And yes, while there are ways with some creative legal drafting to build in certain legal provisions into this irrevocable trust so that a basis step up can still be achieved by the beneficiaries, that gets a little tricky. But most people don't need to worry about, getting that tricky, because most people don't establish irrevocable trust. They're not done that often. By far, the most common kind of trust is a revocable trust. I like to call it sort of the mainframe or the Chevy Impala of estate planning. It's the revocable trust that's used to avoid probate, to make things smooth and easy for your family, and if necessary, protect your kids' inheritance from divorcing spouses and lawsuits. With a revocable trust, all is good on the basis front. A step up in basis is available to the heirs. So if you'd like to know a little bit more about whether assets in a trust get a step up in basis, and maybe how we can help you, we'd love to talk to you. So we invite you to schedule a free 15-minute discovery phone call. Scheduling is really easy. Just go to the link at the bottom of this video, and boom, takes you right to our booking calendar. Pick the day and time that works for you. If you've not yet subscribed to this channel, we would love for you to do that. And also do like and share the video if you've enjoyed what you've heard. So Bill O'Leary signing off for now. Go make it a great day, and go make it a better world.